Hey everyone, Laura here, and today I'm going to do a video that's going to be a longer video, which I don't usually do because frankly, I'm not extremely comfortable on video, but I'm being told that video is the wave of the future. We got to suck it up and start doing it, so I'm going to do it. I'm doing it. And today we're going to talk about, I know this isn't a really sexy subject, but we're talking about landlords and tenants. And yes, I'm a real estate agent, and you might think, well, what do you care? You buy and sell houses. Yes, this is true, but so many of my friends are renting right now, and frankly, it's confusing about what a landlord can and can't do, what a tenant can and can't do, what are your rights, and they just changed the laws recently, so your girl here, Laura, is going to sort it out for you. I have lots of friends that are renting, and listen, I want to get you into a home. I believe in home ownership, and I know you want to have your own home, and you know, mortgage rates are still high right now. I get it. Maybe you're waiting, so you're still renting, or it's not the right time, and that's cool. I get it. So let me break it down for you, what your landlord can do, what he can't do. And landlords, I hope you're listening to this too, because we don't want you to get in trouble. Don't get in trouble. Like, it's hard enough being a landlord, right? So let me just set the record straight. I get on Facebook, I see these questions everywhere, and some of them are just, I can't believe what I'm seeing. So I thought that this would be helpful to my friends out there in New York, and I don't know how it is anywhere else. I'm talking about New York, and I'm sure that I'm not even covering everything that is to be covered in this, but I got my notes. We got 18 points I got to go over with you, and I'm going to try to get through this quick so you're not sleeping by the end of this. So bear with me. Let's get started. What are your rights as a New York tenant? Okay, here we go. Let's get started. The first one, landlords cannot take advanced rent or security deposits in excess of 1 month's rent. So that's it. This includes additional deposits for pets. This is not to say that they cannot charge you a pet fee. It just means that they can't take any more than 1 month's security rent. So if your rent is $1,000 a month, they can take $1,000 a month. If their pet fees are $50 a month, I don't know, I'm just making up a number. They can only take $1,000 a month. Okay, so 1 month's security is all they're allowed to take. Before, I remember when I was renting, I think they could take like 2 months security and what, like, you know, they had more freedom to do what they wanted. But now it's limited to 1 month's security. That's number one. Number two, landlords must give the tenant the opportunity for a walkthrough prior to moving in. Now, what's important about this is you absolutely should go through the apartment or house, whatever, that you're renting with your landlord prior to you moving in. I would like for you to note any damage, anything that's out of sorts, take pictures of it, do this walkthrough thoroughly. And this way there will be no question when you're moving out, which you're also entitled to a walkthrough when you move out, that there's nothing that can be, he said, she said kind of thing. Like, oh, this hole was already here. And no, it wasn't. Well, yes, it was. Oh, that doorknob was not there. Oh, yeah. Well, no, just go through the apartment with your landlord. Take note of, hey, that hole in the wall is already here. I didn't do that. Take pictures. Then you're going to put together an agreement that says, this house was in perfect condition when I moved in, and it will be returned in perfect condition when I moved out. Or, you know, please note that there was a hole in the wall that was here when we moved in, etc. So, yes, you are entitled to a walkthrough prior to moving in. Note any damages, anything that could be construed as damage. Just note anything. This protects you, and landlords, it protects you too. So make sure you do that. Make sure you sign something that's agreed upon about the condition of the apartment prior to you moving in. And also, when you leave, if your landlord wants to do an inspection, you have the right to be there for this inspection. Make sure you're there so you can both go over the condition of the apartment together. Okay? That's number 2. Number 3, your landlord must return your security deposit within 14 days of you vacating the premises. So your landlord's got 14 days to get your money back to your pocket. However, if they are withholding some of the money because of damage to the apartment, then you have a right to an itemized statement stating what that money is being used to repair or fix or clean, and you have a right to have a copy of that statement. The landlord has a right to retain money for unpaid utilities, damage, or costs associated with removing, storing your belongings. So tenants, just, make a clean break. Make it clean. Just, clean up the apartment. Get your stuff out, and there will be no issues because he or she can retain money for handling your belongings that you left behind. Okay? So 14 days, clean up your stuff. If he's retaining any money, then you have a right to an itemized statement stating what it is and how much it costs. That's number 3. Number 4, landlords cannot evict you or penalize a tenant if they complain to a government agency regarding the condition of their living space. So if you have made complaints to your landlord and have gotten nowhere, and you decide to take it up a notch and you call a government agency complaining about your dwelling, the landlord cannot evict you, get rid of you, kick you out because you did that. So I hope that you are not somebody who's experiencing this, because you want to have a good, open and communicative relationship with your landlord. But if you're not getting anywhere and you feel forced to go this route, your landlord can't kick you out because you called a government agency complaining about the state of your apartment. So that is number 4. Number 5, landlords must provide notice by certified mail when rent is not received. You have a 5-day grace period before any late fees or charges start accruing. So if the landlord did not receive their rent by X day, say your rent is due the 10th of the month, they have to wait till the 15th, and then they can start charging you fees or interest or however it works according to your lease. But they do need to notify you by certified mail that you owe them rent. So you got a 5-day grace period before you start accruing charges. So try to get your rent in on time, people. Number 6, lucky 6, landlords are prohibited from demanding any fee prior to moving into the apartment. So this is basically like those junk fees that you see on like your oil delivery bill and your telephone bill, like your a processing fee, or these charges you don't even understand what they are, but you wind up paying them because you feel like there's no way around it. However, tenants, you are not obligated to that. They cannot charge you any processing fees or non-refundable fees prior to you moving into an apartment. So they can't do that. All they can do is ask you for 1 month's security deposit. Number 7, the background check, right? Right now, landlords are limited in the amount that they can charge you for a background check. Right now, the max is $20. So if your landlord does a background check on you, can only charge you $20, and you have a right to request a copy of the report. Here's something that's new, is that if you have done a background check on yourself and it was done within the last 30 days, you can submit that report to your landlord and they must accept it. So maybe you were going for another apartment and you happen to have a copy of your background, your credit check or background check or whatever. If it's in within the last 30 days, you can submit it to the landlord. They must accept it, and then you won't have to pay the $20 background check fee. So right now, $20 or free if you have a copy of your own background check that was done within 30 days. Number 8, we discussed this just a little bit, but landlords are not permitted to charge rent fees until the rent is at least 5 days late. And that fee can only be the less amount of 5% the monthly rent or $50. So whatever's less, 5% of the monthly rent or $50. That's it. So they can't be charging you exorbitant fees for late payment of rent. So just remember that. The lesser of 5% of the monthly rent or $50. Number 9, this is a new one. If a tenant vacates the property, the landlord must make a reasonable attempt to re-rent the property. If not, then you may be on the hook for the amount of the lease, for the term of the lease. But if you decide to leave prior to that, you were on the hook just automatically. You owed the money, that was it. But now they've changed it so that the landlord, it's up to the landlord to try to find a renter before they can charge you the whatever you owe on your lease. So the landlord has to make a reasonable attempt to find another renter before you're on hook for the remainder of your term, the term of your lease. So they put that on the responsibility of the landlord and not the tenant, which is trying to stay neutral here, but that doesn't seem very fair. But it is what they decided, and that's the law. So the landlord is put in this position of trying to re-rent it. But if he can't, then you might be on the hook for that money. That's number 9. Number 10, landlords must give a 30, 60, or 90-day notice if there's going to be a significant increase in your rent or a lease termination. Now, it depends on how long you have occupied the property as to how long of a notice you get. If you've lived there for less than a year, you'll get a 30-day notice. If you've lived there for 1 to 2 years, you'll get a 60-day notice. If you've lived there for more than 2 years, you will get a 90-day notice. So these, it just depends on how long you've been there as to how long of a notice that you are entitled to receive. And this is for a significant rent increase or a termination of the lease. Those are the time frames that you are entitled to. Okay, number 11. Self-help eviction is a crime. What's self-help eviction? I never heard of this term, but this is when a landlord is getting frustrated because he hasn't been paid for his rent. So he goes in and he removes the front door, or takes all your shit and throws it out on the lawn, or, changes the locks. Yeah, can't do that. As tempting as it may seem to you landlords, don't do it, because it's a misdemeanor. It's a crime if you do that. And they call this self-help eviction. What you have to do is go and obtain a warrant of eviction. Because if you go do the vigilante thing, it's not gonna go well for you, because the tenants have a right to occupy the property without feeling harassed or menaced by the landlord. Don't hate me. I'm just telling you that the law says you can't do that stuff. So landlords, if you've got a tenant that's not cooperating, yeah, don't like go full on vigilante, because it will backfire for you. I'm sorry. But as good as it may feel in your head to just want to rip the door off or take all their stuff out and strew it on the street, you can't do it, okay? So self-help eviction is what that is called. Number 12, rent demands must be in writing and served 14 days before the landlord can start a court case for non-payment. This law has changed because it used to be 3 days. Now they got to wait 14 days before they can start a court case against a tenant for non-payment. So that time frame has increased. Number 13, and this is along the lines with court proceedings, court papers have to be served at least 10 days before the actual court date. So you gotta let a tenant know at least 10 days before the court date. Has to be served within 10 days. Before, it was 3 days. The law has extended this to change it to 10 days. So they need a 10-day notice if they're supposed to be in court. Number 14, if you're in court, landlord, you can't get any non-rent charges in a proceeding. So the only thing you can ask for in a court proceeding regarding your tenant is for the rent that is owed to you. So it can't be like, pain and suffering. It can't be some, made up, charge or whatever. You can only get what's owed to you in rent. Okay, number 15. This has to do with an eviction proceeding. The court can adjourn an eviction proceeding at the request of either party for 14 days, and it isn't necessary for either party to explain why they need a stay. So this law changed. It used to be 10 days, and if a party wanted to adjourn a proceeding, they needed to have a reason. But now, apparently, you don't need a reason. You can just say, I don't feel like going to court. Let's do this again in 2 weeks. And that's all you really need to say. Before, you used to have to prove that you needed to collect evidence for your case, or, it had to be a reason. But now a tenant can just say, I'm supposed to be in court because you're evicting me. Well, yeah, I can't make it tomorrow. Let's do it in 2 weeks. So that did change. It went from 10 days with no reason to 2 weeks. It went from 10 days needing a reason to 2 weeks without needing a reason. I don't know. But that's what it is now. Okay, number 16, let's just hope nobody needs to hear this, but a warrant for eviction must be served 2 weeks before the actual eviction can happen. This was increased quite a bit. It used to be 72 hours before you knew you were getting the boot. Now it's 2 weeks. So they gotta let you know 2 weeks prior to you being evicted, which I hope it doesn't come down to that for you, don't. I hope it just doesn't. But instead of 72 hours, it's 14 days. So you got a little more time. Okay, number 17, a tenant in a non-payment proceeding. You can pony up all the rent that you owe, and then you're good. So they can't, a landlord can't continue with the proceeding. If you pony up all the money that you owe to the landlord, it's considered good. They must accept it, and your tenancy is reinstated. So if it ever comes down to that, maybe you just needed to bide a little time or work an extra gig or whatever it is. But if you give your landlord all the money you owe him, they've got to take it and then move on. They can't keep you from your apartment or your house. Okay, number 18. This is a pretty big one. Under certain circumstances, the court can give a tenant up to 1 year to relocate as long as the tenant is staying up to date with their rent. Now, previously a court could issue a stay for 6 months. Now it's up to a year under certain guidelines. Following guidelines pertain to this. You must be using the property for a dwelling. The application for the stay was made in good faith. And the applicant, the tenant, is filing because they cannot secure a suitable premise in the neighborhood that's similar to the property that they are currently renting. The last criteria is that it would cause extreme hardship to the applicants or their family if the stay was not granted. So what is extreme hardship? Well, the law defines extreme hardship as a serious health problem, a significant exacerbation of an ongoing condition, a child's enrollment in school, or any other extenuating life circumstances that would affect the ability of the applicant or the applicant's family to maintain the same quality of life that they have at the moment. So this is pretty big, because if a landlord wanted to sell his property or wanted to terminate the lease, if a tenant were to continue to pay the rent, but could petition the court for them to stay there, if they met those criteria, they could stay for another year. That's pretty big deal for a landlord. So, I don't know what to say about that, except that, that's a tough one, because if a landlord needs to sell the property and the tenant doesn't want to leave for some of those criteria, they might be able to stay there for up to a year. Before it was 6 months, but now they've extended it for up to a year. So if you're a tenant and you meet some of those hardship requirements, then you might be able to bide some time for a year with your landlord. And that's basically it, I think. Oh, one more thing. Landlords cannot reject a tenant because they had been in court case with a prior landlord. So if your landlord finds out that you were having problems with a previous landlord, he is not allowed to reject you because of that. So that's number 19. And the courts seal all these cases. So a landlord, it's not really easy to find out if you had prior problems with a landlord and had to be taken to court. But if he knew about it and he rejected you based on that, it is unlawful for a landlord to do that. So that's number 19. So there you have it. I hope that that has cleared up some maybe confusion, or maybe you just learned something that you didn't know before. I mean, basically, it has a lot to do with expanded time frames for paperwork, serving warrants, petitions, the stays. Things have to be in writing. You can avoid eviction by paying all your unpaid rent. It puts caps on security deposits and background checks. So if you have any questions that I haven't answered, I'm sorry, but if you need legal advice, don't turn to me. Turn to an attorney. This is just very basic, and I think it's knowledge that both landlords and tenants need to know, and it will save you a lot of headache. Be a good landlord, be a good tenant. Housing is really difficult right now, and I can understand the frustration on both sides. It's a very, very complicated and layered issue. And, when you're ready to buy a house, I'm your girl. I'm waiting for you. I want to get you into a home. If you know somebody that's looking to sell a house, I love to list houses too. So, there's not a lot of inventory for these buyers. And, things are going to get harder for buyers of houses in the future. And maybe I'll talk about that in another video. But for now, thanks for watching if you made it this far. And good luck and happy renting.